Okay, so what to do if an immigration judge rules against you? It's one of those things that almost nobody wants to think about, but it is important to start thinking about that from the beginning of your case. So when somebody comes to my office and we sit down for the consultation, I'm going to be thinking with the whole strategy in line from the first time we see the judge to what happens in the worst case scenario if the judge does rule against you. What can you do, and what options does somebody have? The good thing is that there usually is an option. So if the immigration judge rules against you, either denies your case for whatever reason they might have, you can usually appeal that decision. So very important is that from the date that the judge rules against you, denies your case, you have 30 days. It's a very strict deadline. If you miss it, it is very hard to recover from that. So you want to make sure that you reserve appeal. So the immigration judge will typically ask if you want to appeal that decision, and you should always say yes. Scratch that. You should usually say yes if you want to continue fighting your case. So the first thing is when the judge rules against you and he or she asks, do you want to reserve appeal? Say yes. That will give you an automatic 30 days for you to file that appeal. If you don't file that appeal in 30 days, then it's abandoned and that judge's order becomes final. But what you want to do is within those 30 days, file your E-26. It's the notice of appeal. You have to send that to a court, the Board of Immigration Appeals, which is located in Virginia. Nowadays, most cases are online, so you would file it online with the Board of Immigration Appeals. You also have to pay the filing fee. The filing fee just increased this year. It used to be $110, and now it's $1,010. So you want to make sure you have that filing fee paid when you file your notice of appeal. And in some circumstances, somebody might qualify for a fee waiver. So if you are under those circumstances where you qualify for a fee waiver, then you want to make sure to file that with your notice of appeal. Usually in a case that gets appealed to the Board of Immigration Appeals, the first step is, like I mentioned, you reserve appeal with the judge. Then within those 30 days, you file that notice of appeal to the Board of Immigration Appeals and you pay that filing fee. After that, you will receive a receipt. Very important to set a deadline to remind yourself to look for that receipt. If you don't receive a receipt, that is a clue that something might be wrong. So you want to make sure to keep that in mind. You need to receive a receipt. That'll be the proof that you filed it. If you don't receive something, then you want to contact the Board of Immigration Appeals and see what's going on. They might not have received it. There might have been a problem, and you want to, if there is a problem, you want to find that as soon as possible. But hopefully you filed it properly, you paid the fees, they accepted it, and you got your receipt. So after that, you're basically going to be waiting for a while. These cases, they're taking anywhere from 2 to 3 years, sometimes even 4 to 5 years in total from when you file it to when you get the decision. So you're going to be waiting, but eventually they are going to send you a briefing schedule for you to submit your brief, which are your arguments of why you think that the immigration judge was wrong, whether they erred as a matter of law, they got the law wrong, they didn't apply the law correctly to your case, or whether they erred as a matter of fact, that they got some of the facts wrong in your case. Usually, you're not allowed to introduce new evidence at this stage. A lot of people think that they can bring more evidence, but usually if you should have had the chance to file that in the stage before with the immigration judge, this will be mainly arguing the law or the facts of your case. So you get that briefing schedule. Again, they give you very short and very strict deadlines that you have to comply with. They'll usually give about 3 weeks from when they send you that order to submit your brief to the date that you have to submit it. You want to probably have been working on it before that, so that by the time you get that order, you are ready, and then you file this brief to the Board of Immigration Appeals, and then from there you're going to wait a little bit longer. The government also has a chance to file their brief with their arguments and their opposition or their position, and then the Board of Immigration Appeals is going to decide. They will either dismiss your appeal, and that happens whenever they say that the judge didn't make a mistake and they were correct, and so their order stands and they dismiss the appeal. They can also overturn the decision and say that the judge got it wrong and the judge should have granted this case, and they could issue an order granting the case. Or more than likely what they usually would do is either the first one dismiss it altogether or remand it back to the immigration judge and give the judge instructions on what they did wrong and how to correct it, and they give the judge another opportunity to make the correct decision. And then depending on what that subsequent decision is, whether they grant it then or they find another reason to deny it, then this process might continue for another time. Either you might appeal that decision if the judge still denied your case after the appeal remand, or maybe if the judge changed and granted your case, now maybe the government might appeal. So this can go on for a few different rounds. However, I always say if you win on appeal and it gets remanded, that's a very big thing. That's a victory. You're one. That's a good thing. So I would be happy with the remand usually for my clients. Some tips for filing an appeal, for doing this process, is you want to make sure to always request a panel of at the Board of Immigration Appeals. Some appeals, they go to a single judge, and that judge and the Board of Immigration Appeals can make a decision on your case. But for certain cases, especially when they're of national importance, which a lot of cases in immigration law can fall under that, those can go to a 3-member panel. And so that's usually recommended to request that from the beginning, that you want your case to be heard by a 3-member panel. At the very end, the Board of Immigration Appeals, if they dismiss your appeal, one important thing to know is that after the Board of Immigration Appeals dismisses it, then you also have 30 days to file a petition for review with a federal court of appeals. And that's another very strict deadline. So if you happen to get a dismissal in your appeal at the Board of Immigration Appeals, you want to make sure to go as soon as possible and talk to a very trustworthy immigration lawyer, that they can help you determine if you have a case to appeal to the Fifth Circuit or to the Federal Circuit Court, wherever you find yourself. If you don't then appeal that, then at that point the immigration judge's order becomes final. And so if they denied your case and ordered a order of removal, then at that point you will be in danger of being picked up and removed from the country, or you have to go and start the process of turning yourself to ICE, to immigration, and doing the process of being removed from the country, or asking to be allowed to leave voluntarily on your own volition.